Welcome back. Thank you so much for joining us again for our second panel. We have an excellent lineup here. I'm so excited for each and every one of these individuals to share their expertise with you. Starting with Dr. Rachel Hendrick-Stirrup. She is a member of the Duke University and Ohio University academic and research communities and has published numerous original privacy and health research articles. Dr. Hendrick-Stirrup brings to the panel a diverse background with formal educational training in hard sciences, legal studies, and medicine. Previously, Dr. Hendrick-Stirrup was the Health Policy Counsel and lead at the Future for Privacy Forum. Currently, she serves as the Research Director of Real-World Evidence at the Margolis Institute for Health Policy at Duke in Washington, D.C. Justin Sherman is an adjunct professor here at Duke University's Stanford School of Public Policy, where he runs the research program on data brokerage. He's also the founder and CEO of Global Cyber Strategies, a Washington, D.C.-based research and advisory firm. He's a non-residential fellow at the Atlantic Council, a contributing editor at Lawfare, and an op-ed columnist at Slate. His work focuses on cybersecurity and data privacy, technology and internet policy, and geopolitics. And you might be familiar with his work as featured on HBO's Last Night Tonight with John Oliver. Manisha Mithal is a partner in the privacy and cybersecurity practice in the Washington, D.C. office of Wilson Santini, Goodrich, and Rosati, where she advises clients on privacy, cybersecurity, and consumer protection matters. She represents companies in regulatory investigations. She is an internationally recognized expert on privacy and data security, having formerly led the Federal Trade Commission's Division of Privacy and Identity Protection. She led the negotiation of numerous privacy and data security settlements and managed the first litigated FTC decisions on cybersecurity issues. Finally, Tim Spadapani is the principal at SPQR Strategies. He's a legislative, legal, and strategic consultant who helps companies and consumer and privacy advocates understand and respond to the pressures created for businesses, consumers, and governments by emerging technologies. Tim's specialties are privacy, online safety, content moderation, and constitutional law. As the first director of public policy at Facebook, he was responsible for developing and implementing the company's interaction with the federal, state, local, and foreign governments and policymakers. This panel will be moderated by Professor David Hoffman.
Thanks, Safa. All right, what a hard act to follow behind Mark and David. But this panel, I know, is up to the challenge. But Mark and David, and then the reference to John Oliver, we're going to have to really be on our game to be as entertaining as we can be. While what we're going to do is widen the aperture right now. Now, we focused, and David and Mark focused on mental health apps and the collection and data transfer practices of that. Now we're broadening to health data more across the entire spectrum of what's collected and processed in a non-clinical healthcare environment. And we're going to dig in there and really try to go into some detail. Mark said the laws suck. And so we're going to try to now figure out, what do we mean by the laws suck? And what would we do to actually make them better so that we're not also losing the value that we can get from the innovative processing of health data, but still that where we can mitigate these harms. So I want to get quickly to our panel so we can get into the detail. Rachel, could you talk to us more broadly about what is this wider aperture of health data that we want to be talking about?
Yeah, so when we think about health data, many of us probably think of, oh, yeah, the data I provide or that's collected when I go to the doctor, and that's protected by HIPAA, right? You know, I go to the doctor, they enter in, data in their computers into my electronic health record. I can, if some of you have access to something like this, I can log into my chart and see all of my health records. Like, that's my health data. But today, we're seeing health data collected in a wide range, in a growing range of contexts, some of which were discussed today in the form of mental health apps. But there are several other apps that are health related, seemingly not so obvious, actually. So real world data is often considered to be big data, where it's data generated basically anywhere. It could be your geolocation data, your ride app history data, data that you generate at the grocery store, your music streaming data, even any source of data on your mobile device, really. Social media data, in fact, is considered, real world data or big data. Even your credit card statement history, a lot of that is part of the real world data landscape. And I think many people think that that data or assume that that data is not related to their health. How could it be? I didn't give or provide that data when I was at the doctor. But all of that data can reveal a lot about your health. Your credit card statements, as far as you making co-payments at the doctor, or your debit card statements can reveal that. Your ride app sharing history, if you happen to take a ride to a doctor's office, whether it's a community clinic or a hospital, it could be a mental health facility, it could be an abortion clinic, abortion care clinic. It could be essentially anything like that. Also, your music streaming data, if you're downloading meditation music or things like that, it's all or can be related to your health. But many people don't think about it that way because they said, health data is this. It's the data that I generate at the doctor. That's it. But what companies know is that, again, and as we've learned, that health data is very multifaceted and is highly contextual. So today we're challenged with the notion of educating ourselves and the community and policymakers with having that understanding where it's not black and white. It's not this bifurcation of health data and not health data. It's about to what extent can data be generated and used to draw conclusions or to make inferences about my health or the population's health. And that can be especially true for the health of populations who have unique healthcare needs. So thinking about female sex populations, as they have to, see a specific type of doctor for that. Or looking more into that, females who are of childbirthing ages and who belong to or who have families of childbirthing ages. What does that mean as well? That's a very protected sort of subgroup or subpopulation of individuals that have very unique data. And therefore, that data, they can be targeted based on that data profile to which they belong. So as we talk more about all of this today, and as we think about the plethora of health data types, and as we think about how that data can be collected and or used and or shared for a wide variety of purposes, whether it's for, as we talked about today, advertising purposes or for research, for healthcare, or just for some other purpose that maybe we haven't even thought about yet. We have to really think about health data being highly contextual and not just black and white by definition. That's usually the easy way to think about it, but it's very complex, and so let's dive into that complexity today.
What I love about what you're pointing out, one of the many things is we're not just talking about data that very explicitly you provide that is about your health, but it's the inferences also on top of that. Manisha, Mark said the laws suck. I'll say one thing I feel very strongly about, that whether the laws suck or not, the tireless efforts of government civil servants who have worked to try to implement the laws that are there to protect privacy clearly do not suck. And your time as Bureau Director at the FTC and the actions that were taken with the tools that you had were amazing. And I'm wondering if you could describe a little bit about what the laws are in more detail and what their limitations are and how maybe the states are filling in for gaps that might be there at the federal level.
Sure, absolutely. Thanks, David. So I think it might be useful to view this from a historical lens. So back in the 90s, people were concerned about health privacy, and so Congress enacted HIPAA, and they thought, okay, this takes care of the health privacy problem because HIPAA covers information that you share with your doctor, insurance companies, hospitals, and so it was thought that, kind of that takes care of the problem. So that was in the 90s. Then in around 2008, 2009 period, we saw proliferation we started to see a proliferation of these vendors of personal health records. And so these were companies like Google Health, products like Microsoft Health Vault, where the idea was that the consumer would be in charge of their medical information. They'd go to their dermatologist, and they'd go to their orthopedist, and they'd go to their general specialist and compile all the information into a personal health record. And so Congress enacted a law requiring breach notification for any security breach of your personal health records. And so the FTC implemented that law. But then we saw that those companies really didn't flourish outside of the HIPAA space. So a lot of these companies that were offering these personal health records, these were the companies like MyChart and others. And so that was in the HIPAA bucket. So that didn't really pan out as we thought it would. So that was kind of late 2009. So then in the last 10 years, the FTC had been, where the agency I was at, was recommending legislation. They were recommending that Congress enact general privacy legislation. And it became clear that Congress wasn't going to do that. And so my agency, the FTC, said, okay, well, what can we do with the laws we have? There's no health privacy law that we enforce other than this law applicable to personal health records. And so the FTC began to use its general authority to go after some of these unsavory practices in the health privacy area. And there's three pieces of that. So the general FTC law is the FTC Act, which prohibits deceptive or unfair practices. So the first prong is deception. And so the FTC brought a number of cases where companies said, we're not going to share your information with third parties, and they did. The FTC brought a number of cases, just as an example. There was a company that said, provide feedback to your doctor. And in reality, they were using the feedback to generate this public Yelp for doctors. And as a result, consumers they thought their communication was only going to go to their doctor, but they saw their communications on the internet on these review sites. And so the FTC said that the company was engaged in deceptive practice. And so that's just an example of the kind of health privacy case the FTC was bringing. This was probably 7-8 years ago. The second prong that the FTC has been more aggressively using, particularly in the last few years, you heard the mention of the BetterHelp case. So the FTC is now saying that it is an unfair practice to take information and share it with others, this sensitive health information, without the notice and consent of consumers. The FTC also said it's an unfair practice to fail to generally have systems in place to protect health data. So in this way, the FTC has been expanding this idea of unfair deceptive practices in the health space. And then the third thing that the FTC is using, so recall I talked about this law that was applicable to personal health records. So the FTC said, hey, wait a minute, we're going to parse this law, and we're going to say, you know what? It was originally meant for this idea of like a portable health record. But the way we see the language, we can actually get at many of these third-party health apps, these third-party health connected devices. And so in recent cases, the FTC has said that any app that allows interconnectivity with, say, your Google Calendar or your Fitbit, that would be covered as a personal health record. And so it's shoehorned this idea that this law that was originally applicable to personal health records is now applicable to third-party apps. And there's a lot of controversy around that. The FTC has gotten a lot of pushback for its broadened interpretation. But I think the agency is really just trying to step in and try to fill in the gaps that are left by Congress to further some of the policy goals that Mark talked about today. And I think what's interesting, one of the interesting things about the evolution of the FTC, and we can talk more about this, is that I think the idea of notice and choice right now is very vilified. So as Mark said, we don't want to put the burden on consumers to make these decisions and to kind of sift through privacy policies. Nobody's really going to do that. And so one of the things the FTC has done in these recent cases, it said, we're not going to make the consumer make choices. We're just going to ban these apps from targeted advertising. We are going to require them to delete data after they no longer have a business reason to keep it. And we're going to put in these substantive protections in these orders so that it's not just about consumers making choices. So I think that's been a real innovative way that the FTC has approached these issues. And we can talk a little bit about pros and cons of that. And then, David, you asked about the states. So there's general state privacy legislation. Again, states have come in to fill in the gaps left by Congress for not enacting comprehensive privacy legislation. But we're starting to see, particularly post-Dobbs, states like Washington that have enacted laws called, their laws called the My Health, My Data Act, which defines health information extremely broadly to cover location information, to cover biometric information, to cover inferences, the kind Rachel was just talking about. And if the law applies, and there's a number of requirements that companies have, data minimization, data security, there's a kind of a double opt-in consent before, you have to get consent at the collection stage. You have to get consent anytime you're sharing health data with third parties. So I think we're seeing a lot of creative approaches simply because Congress hasn't acted. And we can talk more about that. And I think when we get into the discussion section, I want to talk about potential policy solutions, bans on targeted advertising, but I'll stop from there.
That is absolutely perfect. So we've now set up the broader idea of what kind of health data that we're talking about and how that can be, and an idea of what's the general scope of the laws that are being applied to it. I want to transition a little bit into talking about the different problems that potentially need to be solved now. And Justin, it's already been referenced your work being on the John Oliver show and the work that you did to make that Data Broker episode possible. You've also been on PBS NewsHour talking about your research, and you've also testified to Congress multiple times about this. Can you talk a little bit about what has it been, the harms and the problems that your research has exposed? Why has it gotten that much attention when people actually start understanding it?
Yeah, so this is the optimistic part of the panel, if you can't tell. So data brokers, right, is what we're talking about and what our project looks at. So these are companies that are involved in collecting and aggregating data, but the purpose is really to sell it. Right, so plenty of companies will do data use internally, they'll do targeted ads, as we've been talking about, right? With data brokers, the sale is really the defining feature. That's how they make their money, that's packaging identifiable data, aggregated data, metadata, inferred data, all kinds of data, and it's all about the sale. So this is a multi-billion-dollar industry in the United States. So hundreds and thousands of companies involved in this practice of collecting people's information, aggregating it, putting it together, and then selling it. And so just to spend half a second on this, we are in a law school, so how do you define a data broker? That's kind of an interesting question. There are only 4 laws at the state level in the US that actually define what is a data broker. So those are in California, Vermont, Texas, and Oregon. And they all say the same thing, which is that you are a data broker if you are a company collecting and selling personal data and you do not have a business relationship with the consumer. Translation, if I set up a website and sell all the data on my users, not a data broker under that definition. If I'm a social media company or a search engine, as Mark referenced earlier, right? I collect all the browsing searches that people have been making on my platform, sell that with their names. I'm not a data broker because I have a direct relationship with that company. So that's the approach that those 4 laws take. That is not the approach that we have taken at Duke. That is not the approach either that the FTC or the Consumer Financial Protection Bureau, the CFPB, have taken. And I mention this, again, just for context, but it's also very relevant in the mental health case, which is that you can't talk about this sale of data without talking about the first-party companies that collect and then sell it. There would not be a market for location data today, for where does your phone go, who's visiting what when, if it was not for hundreds, thousands of mobile apps that collect that on their customers and users and then sell that to data brokers. So the same thing applies with mental health apps, right? There's some level of activity that can go on from scraping public records and things of that sort, but when we talk about companies out there selling mental health data, it comes from mental health apps. It comes from pharmacies, which we can talk more about, that have wacky carve-outs on what they can do with your data. But so that's how that gets out there. But so what are we actually talking about, right? So data brokers sell all kinds of data, and in the health space, this includes basically everything you can think of. So you can go out there and buy lists of people with cancer, people suffering from depression, people who've had thoughts of suicide. You can buy, millennial coffee drinkers in Manhattan, right? There are lists that are certainly more innocuous. But in the mental health space, right, it orients around the conditions people have, the facilities they visit for treatment, even specific prescriptions. And we had a student, Joanne Kim, I'll give credit, while an undergrad, who published a fantastic thesis looking at this problem. And you can even actually go out there and literally sense a person by what prescription are you taking, what specific prescription are you taking, the dosage, this, that, and the other thing, for which condition. And so I say all this to say we're dealing with this space, as has been mentioned, right, where there are plenty of companies operating outside the scope of HIPAA that handle mental health data, right? And as folks have said, there are companies that have better practices. There are apps that are not out there selling it on the open market. There are companies that institute data protection and anonymization requirements. But when you look at this landscape, a lot of this is not anonymized. And I think Databrokers really underscores that this idea of consent, and I'll say this as one of the non-lawyers on this panel, is ridiculously stupid and broken in this country, right? How many people read a privacy policy before they use an app? A couple people in the front here don't count. We've got Nina Farahani and some other scholars here. Right, but so people don't read these things. When you read them, as Mark said earlier, it is completely not understandable. There have been empirical studies of this. There was a study probably 15 years ago now that said it would take the average consumer hundreds of hours a year just to read the privacy policies of things that they might already be using. And this was, 2008 or something like this, right? So, but this is especially the case, right, when it's not the company you directly interact with, but when it's a third party that's out there selling health data, mental health data, and this kind of stuff. So I'll just wrap by saying, to tie it to the FTC, and curious what Manisha and others think about this as well. The FTC has been doing a lot around this issue of data brokers and a lot around this issue of companies selling data. So some of this has been health specific. Some of this has been location specific, which is kind of interesting. And this is maybe not a new idea, as we've heard today, that if you go to a health clinic, your phone might be tracking your location. Certainly plenty of folks on this panel have worked this issue for a long time. But this is pretty new in law and regulatory action to say, hey, if you're selling identified location data on where people are traveling, as in some recent FTC orders, you cannot sell location data around certain health facilities. If you are visiting a specialized treatment center for cancer, for HIV, for a mental health condition, right, you cannot sell that location data, because as soon as you sell it, you're giving away that the person visited that place. So lots of harms, lots of concerning things, but I think it's a really interesting space that kind of connects to some of these issues of data you don't think of as health data and stuff we don't necessarily know is out there.
So lots of different harms. And I just have to say, I had a moment early this morning, which I'm going to describe as a Mark Groman moment, which involved a lot of me saying four-letter words. I was listening to the Hard Fork podcast episode. I don't know if a lot of you listened to Hard Fork. It's the most recent episode. And in the opening, they make a claim about a certain collection of health data and actually say, oh, but we don't, and whether it would be used to train AI. And then they say, we don't have to worry about that because HIPAA would protect us. And I'm like, oh my God, this is two of the most respected tech journalists in the world, and they actually don't understand this, and they don't understand and be able to identify what the problems are that actually need to be solved. Tim, you are one of the folks in the community of privacy professionals who I would say spotted these issues the earliest from the inside view that you had in your role at Facebook. With that as your background, could you talk a little bit about what are the solutions? What are the problems we need to solve right now? What are the solutions we should be trying to aim for?
Happy to do so. First, it's such a privilege to be here with you. Thank you so much for the invitation. I'm really excited. It's been an amazing set of conversations already, and I'm excited to be with these brilliant minds on stage. Where to begin? Maybe with a little bit of Shakespeare. don't know the last time you read any Shakespeare. I'm a big fan of Julius Caesar, the play, right? So let me play the role of Mark Antony in Julius Caesar, which is to say, and to paraphrase, I come not to praise HIPAA, I come to bury it. And that's where we should start. It's, to go back to the moment in history, I think my dear friend Ann and I might have been the only people by vintage who were in the room when what was then known as the Kassebaum-Kennedy law was being morphed into what would become HIPAA, right? In the regulatory room when people were discussing how they were going to implement this brand new statute, which, as Manisha said, it was, people were so excited that this statute had been passed. And there were months of hearings to talk about how this act was going to be implemented and what it was going to mean. And within the very first meeting, as a young, about to go to law school individual, I realized immediately the lawyers and the regulators and the lobbyists were being totally obviated by business interests who were already shrinking the act and putting it into this tiny little box. And so hope died in that early period of time. Note that this statute is, as we've said, it's the Health Information Portability and Accountability Act. It is not the health, insurance, portability, it's the Health Insurance Portability and Accountability Act. And it's not, as Mark has just said, a privacy law. It is a data law, right? And from that moment, things went off the rails. So maybe the best way to do this, David, is to do a little bit of thought exercise. If you were going to try to create a health privacy law, you would think about the public policy goals that might be achieved by it. And you'll realize, I think, that HIPAA fails each and every one of these tests. First, you could imagine, and this is Privacy by Tim, that we would deal with what I think is the most powerful human emotion, which is shame. Fight me on this if you will, but I believe that shame is a more powerful human emotion than love or hate. The only two competitors. And in theory, privacy law should be a means of addressing in the law what we all feel is shame. I guarantee every single person in this room feels ashamed about something or could be made to, right? And so privacy law, 800 years of English legal tradition, has been directed in some ways, or at least aspirationally should be directed at resolving shame, right? So what could you do as part of this thought exercise about what a real statute would do? You could, one, help people resolve shame, right? Because if you resolve shame, my theory is that people flourish, individually and collectively. We'll get to this, but HIPAA does not do that. In fact, it allows data to be stigmatized or shared to people who will monetize it and or stigmatize it further. So I don't think it deals with shame. You could advance individual health. Well, this law that we're talking about is about data. It's not about advancing human health. If it were, it would be constructed completely different. It would encourage people to have conversations and it would protect them zealously because then people could feel free to advance their own physical health. Does it deal with collective social welfare or public health? It does not, because if it did, it would be a huge contributing factor to all sorts of beneficial things. We'd be up here praising it instead of burying it, right? But the current statutes, and I'm sorry, the current statute with this regulatory body around it, does not encourage the use of information by companies, by researchers, by this institution that we're here, and all the phenomenal people who could be here to create new medicines, to create new breakthrough treatments. In fact, it makes it like just kind of an afterthought. The data is put into a corner, but it doesn't actually put that data to work. So now we have a data statute that does not achieve any of the things, the key missions of what the statute could do. So this thing fails on every standard, right? So again, if we're going to talk about what we want to do, we should at least choose as a group of public policy experts to achieve at least one of these goals, right? We should either try to reduce shame so people will flourish individually. We should try to help people achieve better health individually, right? Maybe not collectively, but individually, because think about all the individuals and how much, social good would be created by that. We could advance groups' healths, right? And particularly stigmatized groups within society who have been discriminated against, obviated, pushed aside, what have you. We could do targeted exercises with data that would give privilege to that, that quantum of data about people. And if we did any of these things, we would be so much further along. So David, when you ask, what is it that we could do? I think we have to start anew. And I think we have to think about, can we achieve at least one of these three, or at least move the needle in that direction?
So starting anew is a great transition point as we go to the more interactive portion of this panel, which we'll do for a little while, and then we'll open up for questions. And I want us to, for a moment, interrogate this potential goal of advancing human health. I have actually at least tried to pursue for my entire career the dual purposes of saying, can we move towards the ethical and innovative use of data? Can we get the benefits from the data? Mark, Jolyn, I'd love to love online advertising and digital advertising. And I just wish we could get to the point where it wouldn't just be an entry point for cybersecurity attacks and for collection of information that's actually going to be used potentially to harm me. Because I actually see huge benefits, not just from online advertising, but from across the board for the innovative use of data. And so, Rachel, maybe you could talk a little bit first. When you started talking about the broad definition of health data and from what the work that you do around the value from real world evidence and real world data that could be collected, you could talk a little bit about what are the benefits we could get if we could get to this point where we could protect it?
For sure. So, my work involves, at the Duke Margolis Institute for Health Policy, engaging multiple stakeholders, including representatives from the pharmaceutical and academic health system research enterprises to identify together opportunities and best practices for implementing real-world data in research settings with the intended benefit of engaging in patient-centered medical product development. So what does that mean? It means that give patients the power to elect what type of data they want to provide to researchers to facilitate their care, to facilitate care of their loved ones, and also to facilitate the discovery and development of innovative medicines that don't exist today, but that we definitely need for a wide range of conditions, especially mental health conditions. So, as far as looking at these types of benefits in particular, and I am a pharmacologist by training, so not biased at all, but I think also as an individual, as a caregiver, as a patient myself, and as many of you are also patients and have family members with health conditions, or you have health conditions yourselves, I think we all can attest to the value of leveraging data for the purposes that I just described. But we also want assurances, right, that our data will be protected, that our data won't be misused, that there's ethical oversight over the uses of our data for only the purposes for which intent and consent was given by us. So that being said, it's important to take a look at what our laws do and do not provide as far as privacy protections. Obviously, there's HIPAA. Electronic health record data is covered by HIPAA, and it is a source of real-world data and source of real-world evidence subsequently. So there's a layer of protection there. But then as we think about the other broader range of data sources that I initially described and that my colleagues have described, what protections exist for that? So we're looking at as you mentioned, the Washington My Health, My Data Act. That was a landmark bill that became law in July of last year. And within that law, there are exceptions or exemptions rather for research, for data, health data, as they define it in the law, data that can be used to support research, whether that research is sponsored by government or non-governmental institutions, as long as reasonable safeguards are implemented in the process of conducting that research to mitigate any privacy risks associated with the design, conduct, and reporting of the research. There are many other laws like that, state-level privacy laws. We're actually seeing a lot of state-level privacy legislation enacted or signed into law across the United States. We're looking at the state of Oregon, California especially. I think they were carrying the torch initially in the United States. We have a sort of scattershot of various privacy laws that also hold exemptions for research, especially research that involves understanding and or treating a health condition. So I think what we can all consider today is how can we mitigate the harms that are associated with our data being available in spaces or data being shared in spaces that we're less comfortable with, and how do we in fact use that data in ways or sort of usher it into a territory where the data can actually be used for good, where we have unmet needs, where individuals can struggle to just get diagnosed with something so they can get treated. What's possible as far as data collection or data generation in the real world to allow researchers to glean more insight into the natural history of diseases so that they can come to define what the disease is and the diagnostic odyssey for patients can end and treatment can happen sooner than later versus at stages where treatment would have the least benefit to patients. So this is the approach that I take in my research and practice. And I think all of you might want to consider the benefits, particularly in this way as well.
So I want to open it up to the rest of the panel. Comments on benefits from the innovative use of health data and what's necessary to make it so that we could be able to trust that it's going to be used just for those benefits and not to harm us. Thoughts? Tim?
So I'm a big fan of innovation, and I think it's really important. Again, I said earlier, I think it's one of those things that's missing from the current regime. We have not explicitly empowered trusted entities to take this data, which is a valuable thing, and use it for societal benefit. So we have to. How would we do that? We would find ways to align the interests, I think, of researchers, pharmaceutical companies with individuals, right? We would give a privileged relationship that I think could be created in law or in contract, probably, and then give special protections around that so that individuals were empowered to share data with entities which could create value for them and return it to them, right? Again, with mental health, we could find ways to link individuals with mental health providers so they got treatment in a meaningful way in a meaningful amount of time. And then those entities were freed to take that data and do more things to think about how they could provide their services better, faster, more efficiently, at greater scale, and cheaper, right? This is not all that hard. We just don't have anybody's interests aligned yet.
Anisha?
Yeah, I mean, I think that this is a really important part of the conversation is how do we preserve beneficial uses of data while protecting consumer privacy? And I was struck by the conversation between Mark and David earlier, and we talked about this during the break. So I think that the idea that these apps could be free, and we're sitting here on a college campus, but there, where maybe colleges are curating the apps and kind of for privacy issues. But I think about blue collar workers and other people who need support, need the mental health support, and how can they get it for free or low cost? And I do think collection of data for certainly contextual advertising, maybe we could all agree on. If somebody's reading a mental health article, maybe they'll want an ad for a mental health app. And so I think I've heard some advocates talk about kind of absolute limitations on collection of data, but I really do think we need to have more of a use-based model. Where, there's data that's used for, in privacy debates, a lot of data is used for fraud prevention, or a lot of data is swept up, and if it's de-identified and it can be used for positive uses, I think that's really, really important. So I think it's, it's something I struggle with. And I think just going back to and maybe we're kind of previewing other questions here, but going back to the targeted advertising, I think one of the things that the FTC has recently done is said, like, we don't believe in consent, so we're just going to ban these apps from targeted advertising. And I struggle with that because I say, okay, well, what if there was a world in which you could say, okay, here's a privacy protective version of the app where there's no targeted advertising, and that costs $100 a month, and then there's a free version or kind of low cost version where we are going to kind of target ads to you. I think consumers inherently have different privacy preferences. Some people wouldn't mind and would want the free service, and I don't think we should take that choice away from consumers. So this idea that there is no role for consent really bothers me, because I do think that there's that trade-off. Now, you could say, well, how is a consumer ever supposed to understand the extent of targeted advertising? So I do think there needs to be laws and guardrails and things like that, but I think that there has to be a role for consumer consent and choice.
Just in that, and I do want you to comment here, because you and I have spent a lot of time talking about misimpressions that people have had about the research that we've done on data brokers, thinking that we don't see the value that data brokers actually can and do bring when they behave responsibly in the ways that particularly Manisha and Tim are describing. I'm wondering if you could talk a little bit about that.
Well, yeah, so just to say two things more broadly first. One, I think, even though we're saying some similar things and some different things, I think everything we're all saying does underscore the point that was made, that Rachel made at the beginning, right? Which is this is a really important use case. Personally, I think health, public safety, we're not talking about that today, but if we think about where do we need to make sure we are using data effectively, it's disease research, it is diagnosing health conditions, closing massive racial, gender, whatever, class, right, inequity gaps in the health system, right? So I do think that, anyway, so I'm just sort of observing, right, I think we all are agreeing that it is really important in this space more than necessarily some others, even location or whatever else, to think about how can we use health data in beneficial ways. With respect to the app, I do think that's a good point, right? There, companies who are providing these services in this country at least need to make money off of doing that. And so, there is a need to do potentially some data collection or advertising. I think we have to be careful, though, about setting up a false binary where we sort of have a very expensive app or a free app, and then within that, where the data is highly individually identified, targeted, very subject to re-identification, identity linkage, other attacks, and traceable to people, versus like really broad strokes kind of stuff. But yeah, I mean, the points about fraud and whatnot are interesting. I think, of course, in this case, that's not really what we're talking about, right? Fraud prevention tools are not relying on mental health data. That's kind of, that doesn't happen. And so, I think it just comes back to something a few folks had said and Mark has said, right? If we think about advertising broadly, right? We're not talking today about all advertising or getting rid of all advertising or that, right? But where are the guardrails, right? Where are places where we're more concerned about ads going from the data they're collecting about you, and what degree of identifiability do we want that to have? And I just think with mental health, personally, that is a highly invasive area. And I think, this is one space where sometimes, right, it's important to talk about controls and beneficial use, right? And what are the use cases? But I think that skips collection, right? And some companies do this on purpose, right? If you talk about controls, you skip over the collection in the first place. And I think with mental health, right, this is such a sensitive, we've heard from professionals, right? This is such a sensitive area to yourself, both in terms of what that disclosure can do to you, what that you might do to yourself, and just that's really private and intimate to you. So, yeah, so that's what I would say.
Tim, did you want to add on to that?
I do. Look, clinical studies are really expensive. Clinical research, really expensive, hard to achieve, hard to get people to agree to participate, hard to find those people, it costs it takes a long time. And it used to be that both computing power, or the lack thereof, and computer storage and the cost thereof were real impediments. They are no longer and haven't been for a long time. Storage is essentially free. Or darn near so. Computing power has never been more capable. David was at Intel, and the chips have gotten stronger and more powerful with every passing month for about 40 years, right? So we now have the ability to do massive computing power, and we have the ability to do AI and let systems just run. But what we don't have is the ability for individuals who are suffering from a particular malady to share their data and for there to be findings to be made that are unexpected causations and unexpected correlations, right? And we don't do that. And we could easily change our system to create really, again, privileged relationships where we could unleash this data in very focused ways under, controlled circumstances and drop the cost of drug production and research through the floor. We could advance very quickly whether or not a piece of a new pharmaceutical is going to cause unknown or unexpected side effects that are dangerous, right? We could do that, and we could speed up with great public benefit these other impediments, clinical study costs and clinical participation. That's easy, folks.
So I agree. And I do think there's a number of things that we could do and should do that are easy. And I wonder, do we need policy changes to help incentivize organizations to do those things? Manisha, could you talk about what are the policy changes that you think are actually possible? Because I feel actually and feel badly about this, I pursued for maybe over a decade policy changes that are not possible to get in place, although I would have really think they would have made a difference. What's possible?
Oh, that's such a great question. So actually, I think in order to think about what's possible, maybe again, little history. I think that in terms of solutions that have been considered, so first, we had kind of notice and choice. We've talked about how that's, nobody reads privacy policies. That's fraught for many reasons. And then I think in the mid-2010s, we got to a place where we said, okay, well, what about accountability and data stewardship and requiring companies to issue privacy impact assessments and, think about the risks to collecting health data and write down kind of who's going to be able to see the health data, who's not going to be able to see the health data within the company, have chief data protection officers. And it was more of kind of like, okay, let's shift the onus from the consumer, from notice and choice, to the business to have these systems in place. And I think the criticism of that is, okay, well, so you write down a policy and it's like a crappy policy and you implement it and it doesn't really protect consumers. And so now I think what we're hearing as the solution, we have a lot of academics who've talked about this idea of a duty of loyalty in privacy, which essentially is similar to a fiduciary duty in financial transactions. So when I collect your data, I as a company have a fiduciary duty to protect that data, to only collect the data I need, to delete it when I no longer have a business need, to secure it, and to only use that data in the best interests of the consumer. And I think that's a really interesting idea. I don't know how implementable it is. And so I think in terms of what is possible, I think, creating incentives for companies. I think Congress is not going to act. I don't think Congress is going to act. I think, as we've talked about, states have stepped in. I do think that, providing companies with clear guidance of what's permissible, what's not permissible, and, and some of the states have attempted to do that. I think that is probably where we're headed, and then having the FTC bring cases, use the cases to provide the guidance. But, in terms of what's the silver bullet, I don't think there's one. I think there's also a role for technology here. David, I think you were involved in these discussions. I remember, again, around 2010 or so, we talked about this idea of and I forget the name of it, you might remember, that you share a piece of data with the company and every piece of data has code attached to it. And if you're using it in the way that the consumers want you to use it and it's expected, you can use it. And if you try to use it in a different way, it explodes, or there's you just can't technically use it. I would love to see a technical solution like that. But again, I don't know. So there's technical solutions, there's guidance from regulators at the margins. And, I think that's all we can hope for.
Other thoughts on from the panel? Policy changes that we could put in place that would make a difference? Thoughts?
So I'll just keep talking. So Manisha is, I think, really spot on to talk about the unfairness doctrine. It had been, and not to, Mark's going to win, so he just did over here. My opinion is that the unfairness doctrine had been neglected for about 40 years, in part because people who were opposed to the FTC having greater jurisdiction over companies and their use of things like data had freighted it down. And all sorts of legal decisions were made in courts where the use of the unfairness doctrine became more and more difficult. And as a result, the FTC, I think, trying to protect its authority in other areas, shied away from bringing unfairness cases. So I think it's really an enormous benefit to all of us that the FTC has begun to take those cases on and use that as a plank. And we can get deep into that, but I would really like to see us make the unfairness doctrine easier to put into effect, because I think it would empower the FTC, and I think it would empower state attorneys general who have similar authority to do more and better and greater enforcement.
One other thought, privacy is a bipartisan issue, right? We were very close to passing federal privacy legislation. And if you looked at this is the ADPPA, if you looked at the Republican version and the Democratic version, substantively, it was very similar. And so and I think it's just partly because of dysfunction that the law doesn't get passed. So I think on substantive issues, like who wouldn't agree to, just even requiring privacy notices, something as simple as that, or data broker legislation, or, filling in gaps left by HIPAA. So I don't think it's a question of substantive disagreement. I think partly sometimes it's a question of, privacy is not seen as like moving elections. Like I remember, and I think the one area where we could use as a nose under the camel's tent is children's privacy. So maybe the intersection of children and teens and mental health. I think that gets people's juices flowing a little bit. I remember when I was at the FTC, and I think Joe Biden we were told that he was going to mention children's privacy in the State of the Union. And we're like, oh my gosh, we're on the map. And I think that's the piece that seems that people really care about. So I don't really think this is about substance. I actually think it's about politics and policy and incentives and, so I think it'll be interesting to see what happens the next year or two.
And we're going to open up for audience questions in a little bit. I promise we're going to get there. I want us to pursue a couple things first to keep layering on top of this. These reforms, and we're seeing reforms, and some of them actually, I think, have really interesting components of trying new things. I actually think the California Delete Act actually has some provisions in there, and the mechanisms that it would be used, are useful for us to think about ways to execute on individual participation, particularly the way it could empower companies to actually pop up to help individuals be able to exercise their rights. Tim, where are there situations like that from your perspective where we could find reforms that would actually align privacy interests with those interests of innovators to develop solutions?
It's a big question. I think, and Dobbs being maybe the number one example of the worst Supreme Court case in at least 20 years, I'll add another which you probably don't know about or maybe haven't spent a lot of time with, which is CVS Caremark versus the states of New Hampshire and Vermont. This is the case from 2007. I'll try to keep this brief for the non-lawyers in the room, which effectively said corporations have a First Amendment free speech right. And what is that speech right? They are able to take the data which you share with them, even if you don't know you're sharing with them, and they are able to use it for all sorts of monetization because it's a speech question. So what did this do? This shut down the very effective brand new laws from the states of New Hampshire and Vermont, which had begun to outlaw practices from data brokers, and it stopped the sale from CVS, a massive an absolutely large pharmaceutical company with a PBM behind it, right, where they were taking the data of everything you bought there, your condoms, your tests, your, whatever it's going to be, and they were inferring that data and then they were selling it to everybody. And the states of New Hampshire and Vermont said, this is ridiculous, and we're going to stop the brokerage of this right away. The case goes up to the Supreme Court, and the Supreme Court says, corporations have a free speech right. I think that's bananas. So we need to have that undone as soon as possible. The second place this happens a lot is that when HIPAA was created, the folks in Congress carved out from HIPAA's regulatory structure any educational data. And that's pushed over because there was another statute called FERPA, which regulates not businesses, but actual educational institutions which take public money. So K-12 schools, big universities, colleges, anything that's taking public money, if there's data about you, this institution, other institutions like it, are regulated under that statute. But what happens is that if any of you are parents, or you can imagine your own situation, back when you were in, K-12, you had to go to the doctor's office and you had a condition and your mom or dad, or whoever your guardian is, sent off information to school and said, oh, little Susie broke her leg, or Joey's got an infection, or we're going to be out for the following reasons because one of our parents has got cancer. None of that data, when it's shared with an educational institution, and then they share it with any of the software vendors which make schools function, is protected one little bit. So we could do a really easy thing and we could extend some protections in that area so that businesses which are serving software, information, communications, anything else you can imagine in the schools, would have another affirmative duty, a duty of care, to protect that data and not use it for other purposes. There's all sorts of businesses out there that are doing wonderful things to make schools function, to have parents talk to teachers and have school administration function much more easily, but they're not required to do anything about that data other than it's sensitive data, and so it falls back into this sort of FTC bucket. But that's not good enough.
Yeah, and I just want to underline a couple points here. There's a very innovative company here in North Carolina, kind of by the name of Subsalt, that has folks from Subsalt have come here. One of the founders is actually a Duke graduate, and to come and spoken with our students here. And Subsalt's basic premise is the idea of we actually, for a lot of AI solutions, don't need to use the actually personal identifiable information to train algorithms, but we can create synthetic data and provide a lot of privacy protection there. That's a phenomenally privacy protective model, particularly for healthcare data. There's nothing in HIPAA that would require that. But there are policy opportunities there. You could imagine an interpretation of the GDPR requirements around data minimization that would say, wait, you could be training these algorithms with non-identifiable data. And by the way, the anonymization or de-identification standards that currently exist maybe don't actually properly minimize the data because of likelihood of re-identification. To me, these are the kinds of examples where there are innovators out there that want to provide higher levels of privacy for people. And I'm just wondering, like, that's one example where I think we could look at de-identification and to change some policy issues around that. We could look at data minimization. Are there others that you guys would be at, like, your top of your list? Like, hey, let's look at this. It doesn't have to be a new comprehensive privacy law, even though I really want one. But there's some things underneath this that we could do. Any thoughts? Rachel.
One thing I'd like to say, synthetic data is phenomenal for the reasons you state, and I think there's a lot of potential there for research to demonstrate proof of concept as far as protecting data privacy in specific health research contexts. However, I will say that my engagement with medical product development regulators like FDA, they're not as convinced. Applications that they receive to review a potential medical product's safety and efficacy in a clinical trial setting or in real-world settings, synthetic data doesn't make the cut. In fact, FDA is still trying to figure out how to consider real-world data, like about actual humans first. Synthetic data is generated using generative adversarial networks, a form of AI. That is applied to real-world data to generate synthetic data. So FDA feels that until they can figure out real-world data first and how to treat that for purposes of medical product development, they can't even look at synthetic data yet. So again, it depends on the space in which health research is applied. If it's health research for generalizable knowledge, great. But if it's health research to produce a viable medical product, probably not, because they have a fiduciary obligation to the public to ensure that medical products are released onto the market that are safe and efficacious. I didn't have an opportunity to respond to policy that I'd like to see. I do want to address that really quickly. in the time that we have, there was a study that I conducted recently and published in peer-reviewed literature where I conducted a survey of research participants of childbearing ages, and that includes both males and females, men, women, persons of all genders who are of childbearing ages. And I asked them to rate several different types of real-world data sources as either health-related or not health-related. Most of them strongly disagreed or just disagreed generally that geolocation data, for example, is health-related. They said it's not. But other types of data are considered by them to be health-related, like Google search history data, online purchase history data, text message data, emails, et cetera. Now, bearing all of that in mind, I do want to call attention to a few cases that are recent and that tie into the recent debates or in the wake of the Dobbs decision. So I want to share with you all 4 particular cases that are very concerning to me, especially from a research standpoint. Again, bearing in mind all of the findings that I just shared with you all. A company called SafeGraph, it's a data curation company. They sold phone location data generated by over 600 individuals who visited Planned Parenthood clinics, which led to the company issuing a public statement in June 2022. In June 2022, the Center for Investigative Reporting and the Markup also found that Facebook collected data on individuals visiting crisis pregnancy center websites. In 2017, in Mississippi, lawyers used evidence of a woman's online search activity for abortion drugs in a court trial concerning her pregnancy loss. In 2015, in Indiana, a woman's text message data to a friend about taking abortion pills was used to convict her in the court of law for that abortion. So again, please keep all that in mind, and bearing all that in mind, the policies that I'd like to see more often are laws like the Washington My Health, My Data Act. Again, it passed the legislature in the state in April 2023. The law went into effect in July 2023. There are exemptions for research. However, they do include several definitions, one of which is geofence data that essentially covers any data generated by technology that uses GPS coordinates, cell tower connectivity, cellular data, et cetera, Wi-Fi data even, to determine a person's physical location, very specific physical location. And that's very important because, again, the research participants that I surveyed thought that geolocation data was not health related, but in fact it is based on recent events like with SafeGraph. And also the legislature here also recognized things like that, and that also inspired the Senator Bill Cassidy and the Senate Health, Education, Labor, and Pensions Committee to solicit in September of last year information from stakeholders on ways to improve privacy protections of health data to safeguard sensitive information while balancing the need to support medical research. So I would like to see more activity in that particular lane in order to ensure that, again, we're maximizing the benefit of real-world data across health contexts and minimizing the harms that I just outlined and that have occurred in the real world.
2 quick comments.
Yeah, and I just want to extend this just a little bit, and then Justin, I want you to comment. I think when we see things like SafeGraph, and then also Justin's research team has unearthed some similarly horrific practices, particularly around data brokers knowingly targeting victims or people who have been diagnosed with Alzheimer's and dementia and selling that data to scammers. And Justin, maybe you can comment, and if others want to comment. I think actually I wonder if we're going to make much progress here at all until we start treating these issues like we treat other horrible practices for things like financial crimes where people go to jail. Like, do we need privacy perp walks? I have alleged this. Until we get to that point, that we're not going to actually be discouraging this kind of behavior enough. Because right now, it's profitable to be able to do this and to run the risk of enforcement actions. Justin?
Well, I was glad to hear Safegraph. I mean, I don't like that company, but we actually worked on that investigation. So there were a couple that were doing that, but I think, like you said, underscores the location data. I was going to say two things. One, I think synthetic data, right? This is where we need to talk about use cases, because I'm not a health expert, right? But if you can do analytics for health positive reasons on data that's not real people's data and that works, that is amazing. Like, that is a great use of the technology. But again, we should talk about use cases, right? Because if my privacy risk model is I'm concerned about a health organization getting access to the underlying data, but I want them to be able to still further research, then that's a satisfactory solution. If my privacy model is I'm not concerned about the underlying data being seen, I'm concerned about an advertising company building an AI model that can then go and infer data or go and ingest new data and figure out who has X religion, sexual orientation, income level, health condition, right? Then that is not a good solution. But so again, I think very contextual, and again, where the health space should be the priority and not, I will differ from some others, not advertising. The second thing, which I don't know if anyone has said this yet, is and credit to a former longtime leader of this group, the Division of Privacy and Identity Protection at the FTC is like 40 people. It has been that way for years, and that is insane. And I say this for two reasons. One, as a massive credit to every single person who works and has ever worked there. I don't know how they put out this many cases. There have been 5, 6, 8, 10 data broker cases in the last year alone. That's just the issue area I track, right? Let alone everything else. So punching way above their weight. Two, this is a massive industry and legislative failure that there is not more funding. So my policy recommendation, among other things, is give more money to the FTC. And I think what Manisha said, right? I'm not even we can get into Lena Khan, right? There's a lot of concern around antitrust, this, that's very partisan and a bunch of other stuff, right? But on privacy, it is a very bipartisan issue, as Manisha said. There was even recently Christine Wilson, who many folks in here know and know very well, right? Who is a former Republican commissioner of the FTC, who, for all the disagreements on process on antitrust, was very pro-privacy, and in fact, right before she left, wrote statements about the FTC cases saying, yeah, this is great, you should have fined them 10 times as much money. And so, to me, that is one of the more, I don't know if this is doable, who knows what's doable, Congress does nothing, but if we're doing something, right, we should give more, it should not be 40 people doing privacy protection for hundreds of millions of Americans when there are European countries with 800 people running around the office and they have far fewer people in the country. I just think that's insane. So I don't know if you've comments on that.
Yes, +1 to everything you just said.
Yeah.
Completely agree. So I think to David's point about privacy perp walks, I think there's two things that the FTC has done recently that has really made industry sit up and take notice. The first is that they are now naming individual CEOs in privacy cases and data security cases. So there was a data security case against Drizzly Alcohol Delivery Service. CEO was named for not prioritizing security enough. The company had a breach. And I think that, again, now I represent clients, and that's something that I get asked lots of questions about. So I think that's the kind of privacy equivalent of the perp walk. That's number one. Number two, the FTC has required something called algorithmic disgorgement, right? So in the old days, if you collected data and you did it under false pretenses, you deceived people into collecting their data, or you engaged in unfair practices, the remedy was to just delete the data that you unfairly or deceptively collected. And now the FTC is saying, well, not only are we going to require you to delete the data, we're going to require you to delete any algorithms that you have created using that data. And that has been a game changer for companies. And so again, you can fine, a couple of $100,000, maybe that's not a deterrent enough, and companies will just sign and kind of move on. But naming individuals and requiring deletion of intellectual property that the company has created, I think that is a huge deterrent, and I think that's something that the FTC is doing to move the needle.
Because Manisha, am I thinking about that correctly? If they're going to require disgorgement of the data, we're talking about scrapping the algorithm then, right? And having to retrain completely on new data. So potentially years of development and refinement out of the way. That's a real discouragement from actually using data improperly potentially. That phenomenal. That's a great observation. I promised that we were going to open up. I have lots of other questions, but I know I already saw a couple of hands. I think we're going to have folks who are going to have some handheld mics that are going to go around. Let's start with Ann Waldo, and then we are going to go up into the back and then come back here.
First of all, amazing day. Thanks to all of you, including Jolynn and Mark and David in the first panel. My brain is on fire and I'm loving it. So thanks a ton. I'm a longtime health data and consumer privacy lawyer and policy person. And to your question about, is there anything that is doable on the policy front? My first reaction was just to say, oh, absolutely not, but then I, reposed the question. And I actually do think there's something that is viable that would not solve all the problems we're talking about, but would be a meaningful laser strike improvement. And it has to do with de-identification. I've been deeply involved in this for 25 years. There's a lot of urban mythology about de-identification, so be careful what you hear and listen to. De-identification, when done properly, is an incredibly powerful tool. And yes, it can include synthetic data and differential privacy and some new cutting edge stuff, and will need to keep evolving and improving in order to be done responsibly. The HIPAA standard for de-identification of protected health information under HIPAA allows, I think it's the best standard in the world. It allows, it requires the data to be modified such that there is no more than a very small risk of re-identification based on the anticipated recipient under the anticipated circumstances. And the UK Information Commissioner's Office has added to this with this lovely thing called a motivated intruder test that they discuss for several pages, which is highly compatible with this relativistic HIPAA standard. And where that's done properly, it is an incredibly powerful tool for protecting individuals and encouraging all of the types of research that Tim wants to have be facilitated even more easily, and I think we all do. Two things. One is that the state laws are now creating new definitions of de-identification that diverge from HIPAA. We have 17 different definitions for DID in the state laws, and this has been, my reason for existence for the last few years in a lot of ways is trying to get more harmonization and then now trying to help develop tools so that companies can deal with these standards. So having all these divergent standards of what is DID'd is terribly problematic. It's kind of like those cases from the 1930s where truck drivers had to stop at every state line and change their wheels and offload so on. So more harmonization in really good DID standards would be number one. And then number two, this is really important.
And this will be a question, right?
Sorry, a ban on re-identification. This is the thing that I really want to put into the minds of you guys who are doing policy. It's really important to have where data has been de-identified properly, have a ban on the subsequent attempt to re-identification by someone else, subject to appropriate exemptions. And this is already in California law. It was in AB 713 in 2020, and I worked out those exemptions. It could make such a difference for a lot of the things we're talking about.
And I want to hear Mark and the panel's thoughts. And so I will say, in confidential conversations shared with our research team, we've now heard from several folks in the data ecosystem that they are actively re-identifying de-identified clinical health data, and that is their business model, and it is completely, and selling it, and that it's completely legal to do so. And so interested to hear the panel's thoughts on, do we need the ban on re-identification to solve that particular problem? Mark, go ahead.
Here's why I don't agree. And I'm surprised that I think you're going to agree with me. The focus on whether the data is de-identified or not, or personal data or not, is the wrong question. And the problem is that tremendous amount of harm happens from de-identified and synthetic data. Particularly as we have more advanced computing, it is not the right question. The statutes that are exempting de-identified data are creating a problem, that's the wrong debate.
And by that, are you saying, because I do.
Look at the outcome.
I do agree with you
disagree.
that it's that, well, I just want to, that I think what I hear you saying is, I don't need to know who you are to be able to harm you.
Correct.
Okay, and so Manisha, you disagree?
Or I don't need to know everyone to create an algorithm with AI that harms an entire group or community of people.
I mean, so, and Ann and I have had this debate. This is why I think the FTC test is a good one. The FTC says, in order to be de-identified, you have to take reasonable measures to de-identify the data. Number two, you have to make a public commitment that the data is de-identified and that you will not attempt to re-identify it. And that's enforceable. So if you make a public commitment and you don't do it, then the FTC can come after you. And number three, you have to have contractual provisions in place so that if you're sharing de-identified data with downstream entities, those entities have to make commitments not to re-identify the data. So I think that because technology can't solve the de-identification problem completely, because I think you're always going to have motivated people and new technologies that try to re-identify, I think you need administrative solutions, which is the public commitment and the contractual.
Manisha, is there a requirement that the FTC has that those entities actually audit whether the companies that sign those agreements are actually in compliance with them? And does it have adequate staffing to determine whether those audits are actually being done?
Touche.
All right, just wanted to, that, I know that was unfair.
This is a good point. This is working. This is a good point because this just came up in the Xmode case, right? A notorious location data broker, because they had stuff where they sort of, among many other special needs kids and cancer, these were some of the lovely lists they were selling based on your phone data. But one of the many problems was that they were selling data to customers, and then customers would use them out. The FTC discovered multiple instances of this, used that location data outside the scope of what they purchased it for, and they did not know. And when Xmode found out, they did not know which data it was, they did not know what they did with it, there was no detective control auditing mechanism at all. So that's a huge problem. Yeah, I think I would agree with, even though they're different, both of the points about de-identification. I think, it is an important thing that we should push for. Having prohibitions on re-identification, both in law, regulation, and corporate contracts is huge. For companies that share data where I look for good privacy practices, that is one of them, to prohibit re-identification if it's aggregated or anonymized. But I also think, again, we have to talk about risk models, right? And what risk are we concerned about? And I think, I don't think anyone's saying that de-identification fixes everything, but as some folks have raised, if we're concerned about large-scale discrimination in health AI systems, yeah, then we're not as concerned about each individual data point. We're concerned about overall, racist outcomes being reflected in the decisions or whatever it is, right? And so, talking in terms of what is the outcome we're worried about or what is the risk model, I think, which we do a lot in security, not always in privacy, is a good, kind of framing.
So go ahead, Rachel.
Oh, sorry, I just want to mention two things. And you mentioned certain exemptions that should accompany or could accompany prohibitions on re-identification. And I think one of those exemptions could be health research, particularly in instances where re-identification is perhaps needed in order to consent an individual for further engagement in a study. So thinking about a protocol that has a broad research question and generates data to address that research question, but then the research reveals that there are more research questions that can be addressed using that data, but given that the data's been de-identified, depending on the nature of the study or the data use protocol, again, reconsenting the individual is in the best interest of the individual and or their family members. In the event there are potential benefits to the individual such that they should be reconsented into further studies based on findings gleaned from the initial studies. So this is just one particular example where I think exemptions could be of potential benefit.
And it's an area where you could put auditing controls in place, probably without, which might be different than the data broker ecosystem.
Exactly. Yeah. And then and touche on like group harm. It's very possible that depending on the size of a subpopulation, you don't need to target an individual. You can target the group to which they're affiliated. And not only is that most likely in the actual real world, especially as laws and policies are created to target groups of individuals, it's also terrifying. just to know that you could be harmed based on how you decide or how one decides for you, how you affiliate with a particular group or a subgroup.
We had a question in the back, somebody, but now I'm not seeing the hands up. Who are the hands? Grant. Thanks, Safad.
Hey there, Graham Strickland. I think this is primarily for Manisha. You had mentioned bolstering the health breach notification as a way to protect health privacy. Do you think that like fining companies after the fact is a part of the long-term solution of making companies actually proactive? I think of like Duke Hospital embedding metapixels in their patient portals. That seems like insane that they're doing this while the FTC is upping enforcement.
Yeah.
So it seems like that some companies are just not even flinching in response to some of this stuff.
Yeah, I think you raise a great point. I think, so one of the things about the FTC Act that I talked about, if the FTC proves unfair or deceptive practices, it cannot get fines for first-time violations. If it shows a violation of the health breach notification rule, it can get fines for first-time violations. But I think when you think about what are the incentives for companies, I think I think just kind of injunctive relief, not a huge incentive. Fine, a little bit of a better incentive. Individual liability and algorithmic disgorgement, I think, are up here. And I think the other thing that, and I think there's a huge debate around this, and I think it's a healthy debate, about private rights of action. So I think what companies are really scared about is private rights of action. And so if you look at the Illinois Biometric Privacy Law or the Washington My Health, My Data Act, they both have private rights of action. And I think companies spend a lot of resources on those laws because they have a private right of action. I think there's a downside to that because I think there's some innovative products that companies just geofence around Illinois. And I think there's some really innovative products that are not harmful. I know that there's a class action in Illinois involving Oral-B toothbrushes. They collect the biometric information from your tooth or how well you're brushing. It's like how well you're brushing. And then there's a class action because there was a technical violation of BIPA. So I think companies see that, and I think there's maybe an over-deterrence there. But I think you're right that these are all things that should be put in the mix in terms of deterrence and incentives.
Let's not rule out using like supermax prisons or something like that. But I'll keep advocating my position on that. Justin, did you have
I was
something?
going to say, this is where innovative. I'm like, how the heck do you think of doing that? But anyway.
Other questions? Down here in front, and then Christy, and then Ethan. Sorry, Spot.
Okay.
Thank you. Beside policy change, what do you think the key strategies we can use for balancing privacy and innovation? Maybe global initiatives, partnerships, or data agreements, or tools that you are already told? Thank you.
I think one of the things we haven't talked about is so there's policy, there's regulation, there's enforcement actions. I think partnerships, as you mentioned. We haven't talked about self-regulation. And I think that's somewhat controversial in the sense that, a lot of people say, self-regulation, not worth it. It doesn't have it's industry policing itself, that's not going to matter. But I do think, again, in the absence of legislation, I think a lot of people here believe that there should be legislation. But I think that self-regulation with teeth can be useful. So you have, trade associations and groups that are policing their own members, because I think that there is a market incentive because you don't want, you want to make sure you're policing your competitors so that they're not getting a competitive disadvantage by lying or doing something or coloring outside the line, so to speak. So I do think that there's some other, in addition to law and government policy and things that government can do, I think there's a role for technology as talked about. So.
Manisha, I'm wondering, and then maybe Tim can comment on this also. We actually have a history with the FTC of some real successes in that area. And I imagine most folks here have no idea what the National Advertising Division of the Better Business Bureau is. And maybe you could talk about how I think, at least, I don't know if you do, that it largely worked, that model, and helped the FTC be able to efficiently use resources in the false advertising area.
Yeah, absolutely. And to your point, the FTC has very limited resources. And so it can't go after every practice. And so the National Advertising and the Better Business Bureau was created so competitors would have a forum to file complaints about false advertising. And they have a kind of quasi-judicial process. And, and the decisions are typically abided by. And if they're not, then NAD refers those cases to the FTC for priority enforcement. So I think it's a really effective system, and I'd like to see more of that in the privacy area. And we have seen some of it in the privacy area as well, but
Yeah, my first job as a lawyer was to read actually these non-judicial decisions that were coming out of the National Advertising Division to define where we could go with advertising for clients. And so there's a lot there and a lot of power in something like that. Tim?
So remember my rubric that we have to do at least one of the three policy goals, right? And one of them we haven't talked about a lot is how do we, because we're all patients sometime, right? How do we use people's self-interest to drive the right policy outcomes, right? How would we want to be treated if we were in the situation? What new forms of treatment would we want? When David and his colleagues see a patient, they're treating the person, not some anonymous thing. They're treating the person, and if they're doing their job really well, thinking about the individual things that are happening to that individual, what's happening in their life, what medicines have they taken, how old are they, et cetera, write down the criteria. And they're thinking about an individual. So the practice of medicine is still on an individual level. But our data laws do not recognize this, and nor do we do anything to empower it, right? If we did things to make it so that individuals were at the center of these conversations, and like tools were brought to bear to make personalized medicine really possible because we have AI to do it now, we have computing power to do it now, I think the whole structure changes. My feeling is that the very well-intentioned privacy laws from Europe, which drove well-intentioned privacy laws here in the United States, are about to be obviated completely by either quantum computing or AI or both, right? All the things we've done to sort of put data in a little box and hide it over in a corner are about to be blown apart, right? So we have to get ahead of this. And one way to do it is to think about what do we want? One of those things I think we all want is to have much better personal health outcomes. And I think that's something that could be universally agreed to around the globe.
Christy.
Thank you. This is great. I really appreciate both the panel and the back and forth, getting to see some of the conversation. I actually want to build on what you just said about personalized medicine. I think something that hasn't really been covered is how common genomic data is now, especially in a non-healthcare context. Like I get ads for take this DNA test and get your skincare, set up specifically for you, et cetera. Genomic data, to my understanding, is borderline impossible to really de-identify to a meaningful extent. So how does this conversation on privacy shift, or how do we have to adjust it when we're talking about something that realistically can't be de-identified to meet the marks and the standards that we want?
Yeah, so genomic data essentially pervades, like it is an individual through and through. There's no de-identifying that. In fact, when you try to apply, or in instances where one might try to apply a privacy enhancing technology like differential privacy or synthetic data, it could alter, depending on the level of at which the genomic data is available. If it's all the way down to the nucleotide level, for example, that could actually alter the expression of the gene itself and the expression of whatever the gene might cause as far as a phenotype or a visible expression. It could alter that, and that includes the expression of a certain disease or a reaction to an environmental stimuli. So that is a very good question. I agree that I'm also one of those people that feel that genomic data, raw at the molecular level, is not de-identifiable. However, if we consider genomic data in a precision medicine context at the level of a gene variant, for example, or not a variant, a genomic biomarker, for example, the biomarker expression is what we can evaluate in order to take action in clinical care within the precision medicine landscape. So for example, I do a lot of research on a specific, or on one biomarker called CYP2D6. it's a biomarker that's involved in a wide range of drug metabolism and other types of non-drug metabolism in the body. And there are lots of variants or variations of that particular biomarker across the human genome. But again, given that the biomarker has clinical relevance, we can look at that biomarker at a subpopulation level. For example, what percent of the population carries this variant? What percent carries that variant? And from there, we're able to aggregate that variant level data without necessarily having to drill down to the identifiable person who carries that variant in order to carry out precision medicine research and care. Now, however, in cases where there's a variant that is very rare, then yes, the likelihood of identifying an individual is high. So the same logic would apply as far as if you have a low N or a low number of individuals in a population, like a rare disease population, for example, then the likelihood is high, and we'd have to rely on best practices that exist broadly for health data in order to determine how to treat that particular type of genomic data. But those are two different ways, I think, to think about how we can protect the privacy of genomic data, whether by looking at an expression in the form of a biomarker or it not being as possible if we try to de-identify an individual all the way down to the nucleotide level.
Justin, this is another as well, right, area where you can get into the non-HIPAA covered territory, right? The FTC recently did an enforcement action against Vitagene, one of these many direct-to-consumer genetic testing companies that had people's genetic data identified with a bunch of other data unencrypted on a public server. Which is kind of the list of everything you shouldn't do with somebody's genetic data. So there's that, right? This is also, I'll just say quickly, among many different ways you can slice and dice the data broker industry, one would be what can I as an individual buy versus what do large corporations get access to? And this is where I can't go online with a credit card. As much as this would be an interesting study, right? And go buy, Justin Sherman's genetic data or David Hoffman's genetic data, right? But large corporations buy this. You can look up 23andMe has a lot of problems with their hack and everything else going on, but you can go look up what 23andMe has done in the past with GlaxoSmithKline. You can look up with what Ancestry.com sells for millions and millions of dollars, massive databases of genetic information, basically, that people have submitted or analysis of that information. Don't ask me too much about that because that's not my area, but right. So there is this huge market where it's actually not consumers or yet, I hope, advertisers buying it, but there is already a market for companies, again, where they might make a statement about data destruction or something like this after they get your sample and process it. But before that happens, there's transmission of information for a lot of money to large corporations.
Ethan.
Hi, everyone. So thank you all for your time today. There was a little bit of a dialogue earlier about how we can more effectively use health data to be more in line with patient goals, to improve research outcomes. And we see that done to unsurprisingly much higher degrees of success across the pond in Europe. And while they have much different structures, having centralized health data systems and putting patients as the owner of their health data, I'm curious what you guys think are some policies and mechanisms that we can pull over from European healthcare models that are realistically implementable into our current system to make even a little bit of progress in terms of improving our privacy policy and protecting patients and putting them in charge of how their data is shared and how it can be shared.
I do want to flag what our friends across the pond are doing is better than, in many ways, than what we're doing here, but it's not perfect. I work with a research group that is called GA4GH. It's a Genomic Research Alliance, and they actually told me, they're based, the folks that I work with are based in the UK, some in the EU. They actually told me that they do not have a lot of trust, or the public does not have a lot of trust in the health systems there to protect the health data, or at least protect it such that they have the best interests of the patients in mind. In fact, I was informed about a website that was created by folks in the UK called NHS Lied, where they learned that the National Health System was in fact sharing health record data with pharmaceutical companies. And I think patients were upset that they were not at least made aware of that. The privacy safeguards, I'm sure, were in place or are in place, but the transparency, probably not so much. So I think that's, as we think about your question, it's important to draw on or make a distinction between data use transparency and data privacy. But I'll open it up to my colleagues with further comments.
So I think that, and this is kind of a guess, but I think that the fact that the EU has a global privacy law, I do think in some ways it makes it easier for companies to understand what the rules of the road are and make it easier for them to okay, I can do this, I can't do this. I remember when, the pandemic started, it was like March 2020, and I was still at the FTC, and we were getting questions from companies. Well, I know in Europe I can do this because there's a legitimate basis and the law, allows me to do things with a legitimate basis. But these were tech companies, like where governments were asking them to share trend information about COVID because we were just trying to get our arms around COVID. And so I think that just from that anecdotal case, I think that the fact that there is more guidance across the pond through a comprehensive law, I think sometimes makes it easier for companies to be more nimble in trying to figure out what to do with data.
Yeah, we've actually seen companies here in the US like Meta and Google actually publicly state that. They are saying, yes, state level comprehensive privacy law in the US is okay, but we want a national standard because it makes it easier for us the same way, for us to implement our business, the same way it makes it easier for them to implement their business operations in the EU. Even companies here are advocating for a national privacy law. But what that looks like, I think they're trying to influence the legislature as far as like what language should be introduced. And so I think it's incumbent upon all of us here to determine what that language could look like, not just in the best interest of companies, but also the public at large.
I'll add one comment to this, and then Dakota, you're next. So if somebody wants to take you a mic, that would be great. I think, Ethan, the thing I would also additionally recommend is the GDPR really went further than any other law has done, not just to provide rights and substantive obligations on the data processing on organizations, but the requirements around accountability controls to make sure that the organizations would have people, processes, and procedures in place to detect when things are going wrong. And I actually think that's something we could take and do a lot more with here in the United States. Dakota.
Hi, so I think a central theme that we're exploring is this idea that patients deserve to have control over their personal data. And I know that we've shared there's not that much movement from federal policy and lawmakers to make that happen. So in the sense that the FTC is kind of really a leader in ensuring that patients have adequate protections and privacy for their data, what does it look like to have policymakers work with grassroots organizations or think tanks and kind of these third-party non-policy organizations to ensure that patients can, one, have more trust in the data that they can share to boost innovation, and also allow for patients to have more autonomy and choice in how their data is used?
Well, I think in my earlier comments, I talked about the importance of self-regulatory organizations, but I can't underestimate the importance of trade associations, consumer advocacy organizations, patient advocacy organizations. And so I think that, again, when I was at the FTC, we paid a lot of attention to what they were doing. There was a lot of thought leadership, a lot of, that influences policymaking. And so I think as people are looking to careers, I think it's really a crucial role that these organizations play. And I think they can really move the needle on policy issues. And so, I think it's really important.
Other thoughts?
I think it's a great question. These have been all great questions, but I really like this one. I think, as I said earlier, that stigma and shame that comes from it is really an important component. And what public interest groups can do really well, or advocacy organizations can do really well is to destigmatize, right? And then allow, therefore, for better health outcomes to come. You're all too young, thankfully, to have lived through the AIDS crisis. When AIDS was an emerging disease, it was such a frightening thing for people in all sorts of communities. Mostly people who would never be affected by AIDS were told to be afraid of people who had AIDS, right? And there were a series of organizations that brought AIDS patients and people who were in the communities most likely to be affected out into the public light. And by destigmatizing these things, we were able to sort of change the entire discussion and begin to provide care for these individuals and provide focused medical resources towards them. And so it's not so much about privacy as it is about allowing for a conversation so that the data doesn't need to be hidden, but it can be put to good use, in my opinion.
Jacob.
Thank you so much. This has been an incredible panel. I wanted to ask about data of both forensic data and also data for people who've already passed. So I think about I think we talked a lot about the cycles of life and different stages, but I'm just curious now with new technology, maybe, something's discovered about someone's body that can reveal something that violates their family's privacy. I'm just curious who would own that data and how to kind of balance privacy, but also using that for medical research. Thank you.
Yeah, that's a really good question, especially now that a case has settled or settled out of court, I believe, regarding Henrietta Lacks and the use of her immortal cell line for driving $1 billion cancer research industry. I think posthumous data use and or collection falls under that same category, except we're not talking about live biospecimen. We're talking about live data or data that is just sitting there. Certain industries and our companies have their own. For one, that's not a regulated space, to my knowledge. It is industry regulated such that they create their own privacy policies and practices around that. I do think that there is a lot of work to do. There's a lot of understanding that we need to have first, as far as what are potential, what is the potential to consent individuals for uses of their data, after death. Individuals today can consent to the use of their body after they die for scientific research. They can donate their organs. Many of us, I think, they still allow you to indicate whether you're an organ donor on your driver's license. I think maybe having something similar like that about donating your data might emerge. But as far as it being a regulated practice, it's not. And there's a lot of opportunity to determine what could be the best course of action. And also giving individuals perhaps tools or platforms to allow them to indicate what type of data they want to share after they die and with whom. There's a lot of potential there based on my understanding.
I'm really glad you asked this question, Jacob. I just want to layer one thing and then get last thoughts from the panel before we wrap up, which is I think this highlights a problem we were actually planned on talking about the panel a lot of. This is an issue around relying too much also on consent, which is the multi-generational, or what I often refer to as the third-party problem, right? I might share my genome. I now have potentially impacted everyone in my family, right? And so this is where when we think about privacy as notice and consent, we're not capturing all of the harms, and we need to have an understanding what those harms are and have additional protections in place, particularly for practices that are inherently bad, even if an individual has consented to the sharing of information. Last reactions from the panel?
On that point, I do think that's where unfairness comes in, right? And so because deception is, the company has lied to you, and, you might be a person that doesn't have a first-party relationship with the company. And so I think unfairness is what the FTC is now using to take care of that third-party problem, to protect third parties, like bystanders whose location data is captured, even if they didn't download the app. And so I think that's really important.
Thoughts?
We'll need an extension, in addition to fixing the third-party problem, about inferential data. And so we haven't spent enough time yet today about this. This is the undiscovered country and the place we're going, right? What will it mean that systems can infer things about you, people like you, and make decisions for you? And we have to get in front of that. And if we don't, we're going to rue the day that we didn't.
Do people still study the target pregnancy?
Oh, yeah.
type of- Yeah.
Oh, yeah. All right. Well, I think this comes to the point in our program where I start thanking people. First, a round of applause for this panel. I also want to make sure to thank our organizations that sponsored this event and made all of this possible. The Sanford School of Public Policy, Duke Law School, the Science and Society Initiative. Many thanks to Anita Farahani, who is here, and the Margolis Now Institute. And thanks, Rachel, for helping that. None of this would be possible without those organizations. I want to once again give a tremendous thanks to Sophia and to Liz and to Layla and all of the work that you guys did, telling everybody who's watching this, hopefully on the video and in the room, hire them now. Buy and hold, I'm telling you. And then last and certainly foremost, I want to thank Jolynn Dellinger, who has made all of this possible and continues to be the visionary on our campus, inspiring everyone to think hard about these issues and to go out and do the kinds of things like we've seen from our students, to go out and make a practical impact in the world right after they graduate. Jillian, thank you very much. For those who've previously RSVP'd for the lunch session, we are getting started when? 12:15 in what room? In 3000. If you did not previously RSVP, we may have a couple of additional slots, and you could come and talk to Professor Dellinger and I. Thank you so much for coming and attending today.